Hello there, government students. Mr. Williams here, walking and talking you through our next subsection for Section 6, the American Judiciary. We are looking at the Supreme Court. Supreme Court of the United States of America, the highest court in the land for our national government, for the good old U.S. of A. Items that you would have already had touched upon inside the textbook material and we've hinted at or discussed to some degree so far in these screencasts is that the Supreme Court is supposed to be an independent body from the other two bodies of our national government. So again, separation of powers. Every government has the ability to make laws, enforce laws, and interpret laws. The Supreme Court is supposed to be apolitical, meaning they don't play in the game of partisan politics. They're not worried about implementing ideology of their own or their affiliated political party. They are apolitical. They're trying to be impartial and unbiased as often as possible. Does that always happen? Not necessarily. Okay, everybody's human. At times, there can be some judgments, some rulings where maybe politics is being played to an extent. However, Supreme Court of the United States of America, the vast majority of those judges, as quoting a couple of them now, try to be the best judge of the situation that comes across their desk, enters into their chambers, is brought forth to the top court in our land. Okay? So first and foremost, Supreme Court is supposed to be impartial, unbiased. It is the highest powered interpretive body when it comes to law in the U.S. of A. Because it is supposed to be impartial, unbiased, and apolitical, you're not elected to the Supreme Court. You don't have to campaign for this. There's no constituency to please here. Okay? The only way that somebody can be removed is through the impeachment process, very similar to that impeachment process that we covered with the presidency. So you are selected through a checks and balance based process. The executive branch nominates somebody to sit on the Supreme Court, and you sit for life. Okay, so talk about not having to please a constituency here. All right, you're nominated and then confirmed by the United States Senate. So we have the executive branch appointing somebody to this third apolitical, unbiased branch, and then the legislative branch giving the thumbs up, okay, the rubber stamp of approval. So a great example of checks and balances being played out inside of our national government. However, all right, even though politics is not supposed to play in the actual processes carried out by the Supreme Court, the appointment and confirmation process is extremely political. As many of you would have observed with the Brett Kavanaugh confirmation, and some of you, if you're following along a couple of years ago, the Neil Gorsuch, all right, pictured here on the screen, confirmation. Usually senatorial courtesy and ideology of the sitting executive, okay, the sitting president, play and weigh heavily in this appointment and confirmation process. So the politics involved, enormous, okay, enormous, and it can get really, really nasty. The confirmation process is extremely, extremely intense for the Supreme Court justices, as it can be with any of the appointments made by the chief executive to fill the various positions of authority inside of our national government. The Supreme Court as a whole, 9 justices. And believe it or not, there's nothing in the Constitution that says it has to be 9, okay? And this is where we go back to FDR threatening to pack the courts back in the 1930s to ensure that his New Deal legislation that was being enacted by his Democratic Congress would continue to be deemed constitutional and not struck down by the Supreme Court of the United States of America. There is 1 chief justice, and there are 8 associate justices. The chief is considered first among his or her peers, okay? First among equals, so kind of 1A, and everybody else is 1B. Constitutionally speaking, we've noted the requirements to be a representative, to be a senator, to be the president, requirements to be a chief justice or an associate justice, just a justice on the Supreme Court. 0. There are none. No formal requirements. So if you would like to announce your candidacy or your availability, you can do that right now, Thunder students. Right now, you are as qualified as anybody else, formally speaking, to serve as a Supreme Court justice. Okay, so thus far, covered two major things. In general, the overall attitude and or role that a justice in the Supreme Court collectively is supposed to play inside of our national government, and then a bit about the appointment process and the structure. Okay, 9, you've got a chief, you got 8 associates, no formal requirements. Okay, another slide here kind of recapping that for us or providing us greater detail. I'm not going to spend a lot of time going over this. We have touched on this off and on throughout the last several months in government class. It's a grueling process to be appointed and then confirmed as a Supreme Court justice in the United States of America, and politics play an enormous role in the overall appointment and confirmation process. I'll tell you that if it's a Republican president, you're most likely going to get what is considered a conservative justice, or somebody that executes judicial restraint. All right? Reading a book about that right now. It's something called originalism. This not really new concept, but concept that's being pushed more inside of communities discussing the Constitution and discussing the Supreme Court, discussing law in the US of A. This idea that you are trying to uphold the original intent of the Constitution and the law when it was established. Whereas if you have a Democratic president, more often than not associated with more liberal political ideas, you're going to get a liberal justice, somebody that is going to be more interpretive. They're looking to constantly rule to accommodate and adjust for the ever-changing scenarios, landscape, and environment inside of the United States of America. Sometimes they might be referred to as judicial activists. All right. It's a constant back and forth here between, the majority of the justices being more conservative, the majority of justices being more liberal or activist. Surprisingly, you have some that, again, this is their job to just judge the situation as they see it at that time. All of them will use precedent or what's been discussed and ruled in the past. Some will look at that precedent and say, no, that's wrong. And they might make an interpretation that can be deemed as more liberal or activist based, and maybe steer away from their conservative restraint roots. Other times, you have liberal/activist justices that rule in a more conservative manner. So I guess the point I'm getting to is the Supreme Court justices historically haven't always ruled on certain cases in accordance with what their track record is, whether they're considered more of a conservative or liberal justice. And that's okay. They should rule, based off of that situation at that time, past precedent, and the facts. And that's what a lot of them do. But at the end of the day, we'll get into some of the major Supreme Court rulings that have shaped American society. That's kind of your major assignment this week going into next week. And justice ideology, legal, constitutional ideology weighs heavily in whether or not you may or may not be appointed and ultimately confirmed as a Supreme Court justice. Typical justice, old white dudes, just like every other position inside of our national government, historically speaking, okay? The makeup of the Supreme Court has changed drastically, though, over the last 50 years. For the most part, from its inception all the way through the mid-60s, all white, all guys. 1965, though, Thurgood Marshall, the individual that was kind of the lead counsel for the NAACP in the Brown versus Topeka Board of Education case, okay? That case that deemed segregation unconstitutional. Thurgood Marshall was appointed as a justice in 1965 and will serve for the next couple of decades. We get our first female justice, Sandra Day O'Connor, in 1981, appointed by Ronald Reagan. And currently, as of 2018, 5 white dudes, 3 women, with one of those ladies being Hispanic in terms of ethnicity, and 1 African-American male, Clarence Thomas. Okay? Great book there, My Grandfather's Son. I think I referenced that in one of our Zoom calls last week. Clarence Thomas is a phenomenal example about the ridiculously difficult confirmation process, okay? So some fascinating stuff there about the Clarence Thomas confirmation saga. And we saw some difficulties for Neil Gorsuch and Brett Kavanaugh as well. And they're old white dudes, okay? But because of, potential past accusations, each one of those guys was raked across the coals in front of the nation during their Senate confirmation hearings. But the Supreme Court becoming more diverse in terms of identity politics. It has always been relatively diverse when it comes to ideology. There's always somewhat of a balance between those that execute judicial restraint and those that execute judicial activism. And again, those terms can adapt depending upon the era at which we're speaking. Case selection, Supreme Court, going to go through this quickly here. This information is also covered in section 7.2. The Supreme Court has both original and appellate jurisdiction. So if the crimes or the matters are significant enough to and need to be addressed by our highest court in the land, the Supreme Court can claim original jurisdiction. More often than not, though, the Supreme Court is an appellate court. So the case is appealed, challenged, and rises through the ranks of our American judicial system. Cases must have substantial federal or constitutional question, and 90% of the cases that are taken to the Supreme Court, finally make it to that level, are rejected, not listened to, not heard of by the Supreme Court because the Supreme Court thinks that it's unworthy or the ruling below is legitimate. There's not really a just cause to have it be heard by those 9 justices. Okay, about 8,000 cases a year are submitted for the court to hear or to, again, re-examine. Plaintiffs file a petition of, oh man, I don't need to look at it because if I look at the word, I can't pronounce it. But when I just think of it, I can usually pronounce it. Certiorari. I think that's right. I'll go listen to it later on. If I have to correct myself, I'll correct myself in a Zoom meeting. But yeah, if I look at the word, I want to pronounce it incorrectly. But yes, they file a petition of certiorari. That's basically a formal, Latin term for, hey, Supreme Court, review this case, please. All right. Cases are then going to go through a screening process where you have individuals that work for the Supreme Court justices, known as their Supreme Court law clerks, and they're going to whittle those 8,000 down to about a list of 500. Then the justices in secrecy are going to discuss and whittle that list down even more. There's the old rule of 4. So if 4 justices say, hey, we need to check it out, they're going to go ahead and check it out. If 4 justices say we need to reject it, they're going to go ahead and reject it. And yeah, you can have some indecision there, hence the rule of 4, right? Because maybe there's 4 going each way, and then that one that's undecided kind of actually casts the decision-making vote. Okay, so you go from about 8,000 to 500, courtesy work of the law clerks, and then 500 to 150 based off of conversations by those Supreme Court justices. They're then going to have the official motion to have all the information on those 150, all the previous court cases that were held regarding those 150 cases that want to be challenged by either the defendants or the plaintiffs. They're going to have all that information called up. They're going to examine that. Okay, so writs of certiorari. You're going to have the order in the lower courts to send up the records. Then they're going to have of roughly 2/3 of those 150 that they do. They're going to go ahead and just release a written summary. So they're not going to hear any testimony. They basically review all the material, and based off of the reason that it's been appealed to the Supreme Court Court's going to say yay or nay. Okay, so there's going to be 100 briefs, a Supreme Court official decision, and an explanation of why. The 50 cases that are left, they're going to go ahead and be scheduled for oral arguments. You're going to have 30 minutes, the plaintiff and the defendant, to go and speak in front of the Supreme Court. Then the justices return to a secret conference, discuss each case, and then have a simple hand vote with majority rule. There are then going to be briefs issued by all sides of the ledger. Okay, so let's say it's 5 to 4 to 1, 5 to 4. Okay, in favor of the defendant. Okay, so they're going to have somebody write the majority opinion. One of the justices will write a majority opinion. And it's basically going to state why they ruled the way that they ruled, okay, as those 5, okay? You could have somebody rule with the majority, but they got there from a different legal concept. They would write a concurring opinion. So they're not necessarily 100% agreement or disagreement with the majority. They concur with the overall outcome, but they got there through a different means. So you could have a majority opinion and a concurring opinion. Don't have to have both. You could have both. And then, of course, those that disagreed with the majority opinion, the minority opinion here, that's called the dissent, okay? Why you disagree. And there will be dissenting opinions as well. All of these opinions matter going forward, as all of them set certain levels of precedent for future court cases, for future grounds for appeals, for future policy and law that may be enacted by our congressional representation. Okay, so super important, I guess, words, documents going forward for our national government. 5 Supreme Court rulings and how they changed America. This is what we're going to spend a lot of time looking at through the rest of this week and into next week. Marbury v. Madison of 1803. This is essentially the case that gives us this, concept of judicial review, formally gives us this concept of judicial review. Dred Scott v. Sanford, 1857. This is going to be the case, one of the major events that basically, puts the nail in the coffin for the Civil War to take place. Brown versus the Topeka Board of Education. We've noted that in American history. Have talked about that as well in government class. Mapp v. Ohio, Roe v. Wade, and NFIB versus Sebelius, the old Affordable Care Act, or Obamacare, the actual official legal challenging of the constitutionality of Obamacare. We'll talk about that one as well. So we say 5 plus 1 because this one's relatively recent. But there are dozens that have greatly impacted American society and governance throughout the history of the U.S. of A. But these are some major ones that we're going to take a closer look at. That does it for this subsection, okay? Got any questions? Make sure you contact me. And we're out.